Good morning, everyone, or good afternoon from wherever you're watching us. Welcome to another TWIP talk, and this time it's going to be on China. We are very happy to be able to present this topic to you. I will do that together with my colleague Helen. As you know, Taylor Wessing, we are very active in China. We have 3 offices in Beijing, Shanghai, and Hong Kong, and IP is one of the important topics where I advise a lot since now more than a decade being with Taylor Wessing, and also my colleague Helen, who is in Beijing joining us. Say hi, Helen.
Hello everyone. It's a greeting from Beijing.
Thank you so much for being with us. We are trying today to run you through a number of topics which have changed over the past years. And if you look at China, you nowadays see a lot of discussion about the political system and where it goes. What is a bit unnoticed are the changes which have taken place in the area of IP law and trademark law. And we're going to give you a taste of that. Should you later on have a question or a question on in between, please do try to raise them in the message button function, or later on afterwards, send us a message or give us a call. We'd be happy to talk to you. Now let's get started. And in our presentation, we are going to focus on a number of issues. What you see here is first the statistics, because it's important to realize how IP-rich China has become and continues to become. It's a very different place compared to Europe. We'll then come back to changes which already started in 2014, but which do have an impact until today on how you should think about trademark filing strategy and how to oppose and how to defend trademarks you have in the Chinese register, but also how to fend off attacks against your own trademarks. We'll talk a bit about the famous Article 4 of the Trademark Law, which tries to battle bad faith applications. And we will also raise an important overlooked issue, that is copyright registration in China. Finally, we will enter into the realm of enforcement, and we'll talk about the changing practice of evidence preservation orders and interim injunctions. Finally, we will round this whole thing off with some case law to look at, which is also showing how the practice really changes. Let's start with some statistics. If you see here now the trademark application numbers, it's quite notable that there is a huge increase in application. One can hardly imagine 9 million applications in Europe in 1 year, but this is now what is happening in China, meaning also that the place for good trademark gets crowded and the competition and the conflicts increase. This almost naturally has an impact on the time and money one needs to dedicate to take care of one's portfolio in China. I note that the foreign trademark applications have been fairly steady over the years. They have increased, but by far not as much as compared to the Chinese applicants. Now, look at the enforcement side of these rights. You will see an interesting trend as well. What you can see here is that in the year 2010, 2011, when there was a lot of discussion on IP protection and improvement in China, also with the US, there was a peak of administrative enforcement actions. That is something which is rather has declined since then for a number of reasons. It's not so much a political issue, it's also an issue of that the cases get more complicated and that administrative authorities will point you towards the courts if they feel that a case is too difficult or too complex to handle. There's also less of a readiness to pay for the protection of private rights by government resources. And that has led to now a more or less stable case number over the years. Unfortunately, the number of foreign-related cases is no longer reported as regularly as it has been before, a trend which unfortunately also intends to other areas such as patent filings, etc., which may have different reasons. De facto, it does make the picture a bit less clear to outsiders. Now, looking at the courts, enforcement has also picked up significantly. And when you look at the cases of IP related, which may include unfair competition cases, then you'll see that actually there's a huge increase, a huge jump in cases in the year 2015, 2016, 17, now going on to 2020. This trend we predict is likely to continue. People are much more willing to sue nowadays. They are also willing to fight for their IP rights. And what is very important to note, that most of these conflicts are actually domestic conflicts. So foreigners do play some role, but a much lesser role than if they did in the past. If you want to split up the cases and look which type of IP rights are most frequently litigated, you'll find, interestingly enough, that actually other IP cases, notably copyright cases, are among the most strongly litigated ones. Patent cases have increased and continue to increase, but second place still belongs to trademarks. And one reason is certainly that infringements are still quite common. Another one is that nowadays getting damages and damage compensation has become easier, and the trend to receive higher damage awards is also very clear. Here's again for just visualizing this change in the curve. And also here we predict that the number of litigations will continue to go up and courts in China will continue to be super busy. That has an impact also on the process, on how you need to prepare for litigation if you have to or want to engage. And you have to look at how this is going to play out if a competitor resorts to litigation, because it's not likely nowadays that this is going to away quickly. People start to litigate, and they litigate often through all the instances available. Here's some data until 2016 on their foreign-related cases, and there you can see it's actually quite minuscule. If you take a couple of 100,000 cases and you just have 5,000 foreign-related cases, you realize that foreigners are actually less than 1 or 2% of the total. Now we're going to jump back in time and briefly get back to you to recall what changed in 2014, and we'll give you some explanations on how the system has evolved and what we deem as important information for you. This will be done by colleague Helen, and therefore I pass on to you, Helen. The floor is yours.
Yes. Thank you Thomas, for the introduction. So it's my part. Now let's get started. First of all, I want to have a general introduction of the current authorities in charge of trademark issues in China. First we have, before the CTMO, maybe you have heard before, but now it's combined with TRAP. Together we call it CNIPA. So for the normal applications or oppositions, we go to the Trademark Office, CTMO, and for the review case and the invalidations, we go to the TRAP for review. And after the review, if the parties, any parties or both parties, not satisfied with the result, then we can go to the Beijing IP Court for the first instance appeal. And in China, we have 2-instance appeal system. So if not satisfied with the first instance judgment, both parties or any parties can still go to Beijing Higher Court for another trial. And normally for administrative cases like trademark cases, it's very seldom to go to the Supreme Court unless it's found it's worthwhile to file retrial. Okay, so next slides. It's the general introduction of the process of trademark applications. For the new applications, normally first we file applications, and the applications will be examined by the CTMO. The exam will from 2 aspects. First was the formal examination. And then if we pass the formality, then we go to the substantive examination to see whether there's whether there's any similar trademark, or whether there's any excuse or any grounds to be rejected by the office. if we pass both the formality examination and the substantive examination, then the trademark can be published. And we have the 3 months publication period. And if there's no opposition filed within this 3 months period, then the trademark can go registered. And if during the substantive examination, the examiner found there's any reason to reject the application, then we have the chance to appeal before the TRAP. We say if still, as said, if we're not satisfied with the TRAP review outcome, we still can appeal to the Beijing IP Court and the Beijing Higher Court. And now I want to introduce you with the e-filing system. The e-filing system is associated with the new trademark law amendment, new trademark law since September 1st, 2019. And the Trademark Office accepts e-filing currently, except some special proceedings such as review on trademark actions can be filed with e-filing. There's quite many application documents. Before, when we file original POA or any document or the documents in paper, but with the e-filing, we can only need to submit the color scanned copy of the signed POA. So we save to deliver the original documents. And another benefit is the e-filing can shorten the examination period. Before, when we use the paper filing, it takes around 7 to 9 months to get the trademark published. But now with the e-filing, we only needs 4 or 3 months to get it published. And another benefit is with e-filing, we can not only obtain a paper certificate, and also we have the e-certificate to prove the trademark registration. With the e-certificate, it's easier for us to restore, to transfer. And what's more important, before in our enforcement case, if we found kind of infringement or we have to take red action against the fake products, we need to bring the original certificate or the notarized certificate to the local officer. But now with the e-filing, we can bring the e-filing documents because it have another function. It can let others to verify it. Okay, I can show you with an example. Here is the certificate, e-certificate. I mean, compare with the normal paper certificate, we have a QR code here in the right, in the left bottom. Can you see that? I seal some part. And if we scan this code, it goes to the official website of the Trademark Office. And here is the green part. It's in Chinese. It means invalid. It means valid. So with this e-certificate, the local officials, your business partners can immediately verify whether it's a valid certificate. And in Tailun's practice, we use e-filings for new trademark applications, for almost all kinds of recordals and noise cancellations, because we want to get the result, get the certificate as soon as possible. But for some other cases, like oppositions and invalidations, we still use paper filing, because as per our observation, it seems that if we submit evidence in paper, the examiner will examine the case more carefully. And also, we also use paper filing for review on refusal case, because in some of the cases, we need to ask for longer time, examination time, waiting for other proceedings, such as in some cases, we need to find non-use cancellation against the citations. So we need to have more time waiting for the outcome of non-use cancellation. And also sometimes we need to obtain the coexistence agreement from another party. And in most of the cases, the agreement needs to be notarized and legalized, and it also takes time. So you want to use this paper filing to obtain more examination time. And here is the chart for the oppositions and the invalidations. Okay, give you a short introduction. First, if we find a trademark, we want to oppose it, we will find a opposition application. And the opposition will be examined by the CTMO around 9 months to 1 year. If the opposition's valid, which means the examiner supports our claim, then this trademark will be rejected by the CTMO. However, the applicants of this trademark still have a chance to file a review at the tribe. And if both party means the applicants of the trademark or the opposing party not satisfied with the tribe's decision, we have two instances to appeal to the court. And if the other party does not review the opposition decision, then this trademark will be invalid. Another scenario is the opposition is not valid. Which means the trademark can get approved for registration. And then the opponent will have the chance to find the invalidation against this registration at the tribe. And if both parties not satisfied with the invalidation outcome, and can file the appeal to Beijing IP court and then to Beijing higher court, still two instance trial. And now I want to talk about some changes about the new trademark law, but due to the limited time, I will mainly talk about the intention of use and the bad faith claim. The intention of use, as you see from the Thomas earlier chart, that in China we have year by year increasing new trademark applications. So why we have so many applications? Of course, that some parties or some companies need to register trademark for their business, but still in China may be very typical that some companies or individuals or even trademark agency that apply for trademarks, thousands or dozens of trademark for selling this trademark, or blackmail others. If the other party asks for coexistence, they will ask for high price to offer the letter of consent. So that's the reason why we have this Article 4 requires the intention of use. It reads, the law says any natural person, legal person, or other organizations that needs to acquire the exclusive rights to use a trademark in the production, file an application for trademark registration with the trademark office. The application of trademark registrations that is malicious or notified for the purpose of use shall be refused. So how do we judge whether a trademark is with or without the intention of use? In our practice, when we to check whether a mark have the intention or whether the applicants have the intention of use, we will first to see within how many trademarks was held by these applicants, or if they have any related companies, we will see how many trademarks held by them. So as per our observation, for a legal entity, if its trademarks is above 500, and if for an individual, if the applications is above 300, then the CTMO may consider them as without the use intention. Then another fact is about their industry. For example, it is a company engaged in clothes, for example, while it's applied for trademark for pharmaceutical, for food, then we can say it have no intention of use. And also, like the business starters, business sites. For example, if it's a small size company with no registered capital, and it's applied for hundreds of trademarks, it's obvious it have no ability to operate so many trademarks. So in general, it says whether how to decide the mark have the intention of use. We have to do a lot of background check of the company to find evidence and to claim it has or has not the intention of use. And besides the intention of use, there's another claim. Actually, I personally would like to use a lot, a great fan of this bad faith claim. And this bad faith claim accompanies with Article 44 of the Trademark Law. It says, the trademark office shall invalidate the registration trademark if it's acquired by fraud or any other proper means. The fraud is very easy to understand. For example, if the trademark assignment documents signature is forged, then we can claim it's obtained by fraud. And it's quite it's very difficult to describe, but also.
My apologies for the technical glip. This is something which happens in the international business and likely is going to happen more in the future, given also more stringent oversight of data transfers cross-border. Let me just pick up while my colleague Helen joins us again, is on Article 44. This is something which is increasingly popular. You can use it to try to prove the bad faith, because bad faith in itself often does not really result into an immediate claim to invalidate a trademark. But if you have further evidence and further reasons which can indicate that there has been some foul play, this article is indeed more and more successful in the invalidation procedures. Overall, especially if you have the multiple trademark applications or you have an application of names of very prominent organizations and companies, the attempt to sell, etc., this will usually help in making such a claim stick. This also means that one needs to very closely investigate the applicant and try to find as much information about that person as possible. And now I see Helen is joining us again.
Sorry, I'm back.
No worries, Helen. Why don't we try to switch off the video while you talk so our audience can enjoy the slides and potentially we have a better line. You continue, please.
So we have some, as per our experience and the proceedings we have obtained from the CNIPA and from the judge, we have several examples to show what kind of actions can be deemed as improbable means. For example, if the restraint applied for multiple trademarks which are identical or similar with others' trademark, or with higher distinctiveness or popularity, or the restraint applied for multiple trademarks which are identical with or similar to any marks of other corporation, organization, the names, the packaging, the decoration, or commercial signs of goods of other companies. Another one is the restraint sales trademark, or finds an infringement lawsuit against the user of prior trademark after fail to transfer at a higher price. So these three circumstances are the win case we have received to show that those kinds of actions can be deemed as improper actions. So compare with the intention of use, I think the bad faith claim has less requirement on the amount of the trademark applied. As said, if we try to claim the restraint has no intention of use, we have to prove that the other party have applied for hundreds of trademark. But for the bad faith claim, the amount requirement is less, but they have higher requirements on the imitation, the copy, the free riding intention against other famous companies. But anyway, I mean, both claims are very, how to say, it's very easy or good for our attorneys to use, because both of them are not subjective to 5 years statutory deadline limitation. As you may know, if we want to, I mean, oppositions or invalidations, if we claim like a prior similar trademark, claim prior use, or such as copyrights or trade name, we have to stick to the 5 years limitation, which means if the trademark has already been registered for more than 5 years, we cannot use the claim similar trademark prior use to attack them. While the no use intention or bad faith claim does not subject it to this deadline. And the other one is there's no requirement for the opponent or the invalidation applicant to submit evidence to prove its prior use or high reputation of its company or trademark. Another, advantage of this two claim is it's not subject to transfer. For example, in earlier case, if the trademark has already been transferred to another party, even though it's filed in bad faith, the assignee can use the claim or use the excuse of bona fide acquisition. It says, okay, I don't know this trademark is filed in bad faith, but I already paid for this trademark for assignment, so I'm innocent. I'm free to use this mark. But now, if it's under the no use intention and bad faith claim, such bona fide acquisition excuse cannot be standable. Then I want to talk about non-use cancellation. Okay, and for example, if the clients apply for trademark in China, and in summertime, the trademark will be rejected by the CTMO due to prior others prior trademark, similar trademark. So what should we do? One option is to file for opposition and noise cancellation use their prior use, and or as said, we use the no intention or bad faith. But what if those claims are not adoptable? So a possible approach is to use noise cancellation. Noise cancellation is quite easy to file because any party can file the noise cancellation, and even anonymously. Sometimes if the client does not want to reveal itself to the public or to the trademark owner, we can use our staffs then to file the noise cancellation. And the noise cancellation can only be filed after 3 years of the trademark has been registered. For example, if we want to file noise cancellation against a trademark registered today, we have to wait until September 16, 2024 to find the trademark. And who shall bear the burden of proof to prove provide the user evidence? It's the burden of proof is bared on the trademark registrant. So as said, it's very easy for people to file noise cancellation because it has not necessary to do anything. I mean, to provide any arguments or provide any documents to file the noise cancellation. So what's the outcome of the noise cancellation? If no valid evidence can be submitted within the subscribed time, the registration will be cancelled by the CTMO. Therefore, if we can remove a trademark that block our own application through the noise cancellation, I think it's a good approach to move our client's trademark get registered. But on the one hand, noise cancellation can be a very useful tool for us to remove the obstacles for the registration. But on the other hand, it also can be used by other parties to attack our client's own registration. So at this circumstance, we need to find ways to defend our own trademark registration. So we need to provide valid use evidence. The use evidence we talk about here refers to the commercial use of a trademark, such as attaching the trademark to the products, the package, the container, or tag of the products, or applying the trademark on the attached sides of the products manual, introduction brochure, or price list, or apply the trademark to the transaction documents related to the sales of the products, including the sales agreements, invoice, orders, receipts, inspection certificates, or any documents for customer declaration, and or apply for the trademark in media, such as television or broadcasting or public occasions. But please draw attention that the publication needs to be in the public circulation. If the publication is only within the internal publication among the staff, then it cannot be deemed as valid use evidence. Or we can use the evidence in the exhibition, such as the printing documents handouts in the exhibition, or the signboards used in the exhibition. Just now we are talking about the use. So now let's talk about what kind of evidence can be deemed as valid evidence. First of all, the evidence should indicate the trademark in use. For example, if we want to use a sales agreement to prove the use evidence, so we have to, the trademark should be indicated in the sales agreement. And if we want refers to invoice, the trademark shall also be indicated in the invoice. But I know in some commercial practice, the trademark are not normally indicated in the invoice, but just most time I think it's the product's name. So what should we do in this circumstance? Normally we will see whether there's an agreement or other documents match the invoice. For example, whether they have the same contracting party, whether the amount of the sale is the same, whether the payment is the same. So we have to form an evidence chain to prove that the trademark is in use. Another fact is the use should be on the designated goods or service. For example, if the noise cancellation is attacking clothes, so if we provide evidence like sunglasses, then it cannot be deemed as valid evidence. But if we show the evidence on T-shirts, then it can maintain the registration of clothes. So we have to prove the link or the relationship between the products. And the other one fact is the user of the trademark. Basically, the user should be the trademark owner. But if we have proof such as the licensee agreement or the distribution agreement, the use evidence from the licensee or from the distributor can also be deemed as valid evidence. And another fact is the date. The date have to be fell into the 3 years period. And also, the evidence should be in the territory of China. Since Hong Kong, Macau, and Taiwan are not in the same jurisdiction with mainland China. So if there are any evidence from those regions, we cannot deem them as valid evidence. But there are some exceptions. For example, OEM evidence. We know that some foreign companies, they will OEM Chinese companies to produce products, and all those products will be exported to foreign countries. Before, the OEM use evidence are not accepted as valid use evidence, but recent years we have met more cases that recognize that OEM use evidence can be deemed as valid evidence. And there's also a very interesting case that the purchase from foreign websites can be deemed as use evidence. For example, if a Chinese customer, they goes to the foreign websites to purchase the products, and as long as we can prove that this customer is from China, for example, they have a Chinese name, or for some websites, they require the customer to fill in their ID numbers. So through this, we can confirm the customer is from China, and the shipment is also to China. And with those documents, even though the websites, the sales websites is from foreign countries, we can still claim this as valid use evidence in China. And the last fact requirement is the evidence need to be public, genuine, and legal. The public says, for example, if the trademark was used on some staff work reports or some internal publications, then it's not goes to public. So it's deemed as internal documents. So it cannot be deemed as valid. And the genuine evidence means, for example, if the other party have already, in some case, for example, the enforcement case, say this trademark was not under our authorization, so it's kind of infringement. So in another notice cancellation cases, you cannot claim the user by the infringer was valid use evidence. And also, for example, the symbolic use. For example, owning 1 or 2 pieces of invoice with very small sales amount. So we say it's not genuine. It's only symbolic for probably to defend the notice cancellation. And also, if there's a sales contract, but it's between related companies or between related persons, with also can rebut it is not genuine genuine evidence. So the advantage of notice cancellation is obvious. It's very the application is with low cost, and we can find anonymously, and no documents or evidence is needed to find the application. While we have to say at the moment, the notice cancellation also have some disadvantage, because in the notice cancellation proceedings, we have no chance to cross-examination the evidence provided by the other party. And the examination by the examiner is quite lax, according to our experience. So we have to, in some cases, depends on the review procedure. Because in the review procedure, we have the chance to check and review and rebut the evidence provided by the other party. And I see in 70% cases, we won the cancellation through review procedures. Besides the notice cancellation, another approach to overcome the citation in a refusal is to obtain the coexistence agreement, or we say letter of consent, from the owner of the citations. The coexistence agreement is, in most of the cases, is accepted by the CNIPA and the court, unless the trademark, the application trademark and the citations are identical or too similar to be differentiated. And if in that cases, even though we have the coexistence agreement from the owner of the citation, such agreement will not be accepted by the CNIPA or the court. I also want to take this chance to introduce the copyright registration in China, because I know it's different from the practice in Europe. In China, we have the chance to register the copyrightable work with China Copyright Protection Center. And this registration is not only for Chinese companies or individuals, but it's also for foreign companies from the countries of the Berne Convention. So as long as you come from the member countries of Berne Convention, you can registered your copyrightable work in China. Currently, in China, we accept works and the software, like the source code, to be registered as copyrightable work. And for the works, we accept written works, oral works, and many kinds of works in China. But currently, we will mainly talk about the works of fine art because it's most related to the trademarks. You can see that for device mark, we can see we can deem it as a fine work of art and ask for the protection of the center. And also, if it's word and device combination trademark, we can also ask for the registration in China. And even in some time, it's only a watermark, but with special design, it's also protectable in China. The advantage of copyright registration in China is we can use it as a prima facie evidence to prove the ownership of the work. And also, we can use this copyright as prior rights in oppositions and invalidations, regardless the classes. And also in enforcement cases, we can also use the copyright to sue for infringement. And in some cases, if our trademark application was blocked or rejected by the office, by the CNIPA, by the office, we can take copyright as a backup solution for the protection in China. And I think the most advantage of copyright is it's very quick. It only needs 30 working days from the submission to the registration. And also its cost is very low for the registration procedure. So okay, my part is here. So I will give to Thomas for the following topics.
Thank you so much, Helen. And as you can see, the changes in the environment in China requires new measures, starting with thinking about more non-use cancellations and copyright registration. But there's also a big change which has been ongoing since 2017, relating to interim injunctions and evidence preservations. I will try to be rather quick on the main elements in the law and talk a bit about practice and what it may mean for you as a trademark owner or IP owner. First of all, in China, everything starts with the policymakers and with a policy decision. And while there has been a lot of attempts to improve the IP system previously by passing a lot of new laws, one key element which was always lagging behind were actually the courts, which had to rely on a rather old civil procedure law and which had quite stringent procedures on what to do in case of applications. And that often led to low damage awards and no possibility to really get quickly an injunction. Now, something is changing in China. First, one needs to realize that the Communist Party really is serious about wanting to increase the costs of IP infringement. That is quite well put into this document by the General Office of the Communist Party and the State Council, also the two institutions, one the executive, the other one the real power base, shows how serious that is. And it stresses again and again that higher damage awards are needed. And also the CNIPA, as the new super ministry for IP, so to speak, still an agency, but growing in importance, acts increasingly as the right arm and enforcement mechanism and tries to improve enforcement mechanisms also in the criminal area, for example, with the Ministry of Public Security. So you see another paper which has just been issued by the CNIPA. And also the Supreme Court itself is starting to issue a lot of new circulars, opinions, and judicial interpretations to increase mainly, the protection of well-known trademarks, but also of more new types of rights to China, which are deemed as very essential to Chinese industry, that is geographical indications, and the bad faith applications which damage the Chinese system, not only foreign applicants, but also Chinese. If you look at that, you'd say all good for trademarks. One aspect I wanted to mention is that the Supreme People's Court still regards the patent and trade secret protection as probably the more prevalent and more important area. When there was, apart from the IP courts, which were first introduced in Beijing, Shanghai, and Guangzhou, now extended also to other regions, there was also an IP chamber, a kind of a federal circuit of the US introduced at the Supreme People's Court. And that chamber does deal with a lot of cases, but it does not deal with trademark cases. You have to see that the Supreme People's Court has been tasked by the party to do much more and to guide lower level courts and to train them and to be involved. And they have done that on an increasingly high speed and with an increasingly high number of regulations. In the following slides, I will bombard you with some of these regulations. There are more. But the general gist is that the cases the court takes are getting more and more a tool to discipline and to bring other courts in line and to create a clear direction for IP protection. One aspect to mention is also that winning now in front of the SPC, if you manage it to the retrial, is still difficult, and for foreign applicants even more so. There is an element which may be on the political side, but there's also an element that Chinese judges have very high standards when it comes to evidence, very high standards when it comes to Chinese procedures, which sometimes are quite cumbersome and different from what you know from Germany or other jurisdictions in Europe or the US for that matter. One element which one should always also look at is are these draft standards for trademark protection, which have now just been issued for comments, which play down on the level of operational handling of things. It is something which makes commenting worthwhile if you have direct contact with people on the ground doing the drafting. What we do observe is that comments are taken on board probably less and less from a foreign perspective or more from a domestic need perspective. Still, progress is made. And one important guideline I'd like to mention in this slide is the Beijing High Court guidelines on damage compensation. Lots of people have said China always talks and never walks the talk. What about really increased damage compensation? And you find a lot of very detailed regulations, the first time issued and explained by the Beijing High Court in those guidelines. One of them, for example, being that if you're a manufacturing enterprise and you're sued, you should at least pay under statutory damages 200,000 RMBs. Previously, it was just 30 or 40,000 in practice. And that if you're a repeat infringer or malicious infringer, at least 1 to 5 times the original amount. So there is movement, and this movement benefits right owners who are successful in court. One of the biggest changes relates to much more broader and clearer rules on evidence, which started in the end of basically 2019 with the several provisions on evidence in civil proceedings, which contain a lot of important clarifications on electronic data and how to treat web pages, expert witnesses, how to deal with deadlines, notarization and legalization. So the basic framework, which followed the revision of the civil procedure law in 2017. And then on top of that, a very important further interpretation was issued for the IP litigation coming into effect since November last year. To just name a few examples why this is so important is that a lot of typical defense mechanisms like legitimate source defense of an infringer saying, I got this from someone else and I'm not infringing, I'm a victim too, now starts to be more stringent and starts to give you more requirements to prove that you got it really on normal channels and that you had really some proof to show. And on On the other hand, it also gives some exoneration to people who do have exercised reasonable care, duly reasonable care under Chinese standards, which means that there is something for both sides, implementers and IP owners. Important clarification that trap purchases per se are admissible unless they induce and actually solely cause the infringement. Important clarifications on notarization and legalization requirements for evidence coming from abroad, while there is still in practice a very, very big hurdle to take. What is true undoubtedly is that China takes a very serious and difficult procedural approach to any evidence coming from abroad. There have been some improvements on public documents coming from public databases like a patent office, but in reality, on the ground, you will still see courts basically questioning anything which has not been notarized and legalized. And even though these new jurisdictional rules and the rules by the court on evidence introduced a broader acceptability of originals, it still remains very difficult also for electronic evidence coming from a computer or so. So if you do have a case like that and you read those clauses, be aware of that there are some things attached and some hooks attached which are difficult to manage. Overall, there is improvement and also some further interesting menace to abuse of litigation. Courts are grappling with the high amount of cases, with a very limited increase of headcount, and have an extremely high workload. That means if you do take a trademark case to a court, don't assume that you get your hour in court. You get probably 10 minutes on substance. So you have to be, and your attorney has to be very well briefed and has to put the case right in order to really convince the judge. And some of the defenses which are increasingly seen is the claim of an infringer of abusive litigation. Abusive litigation was often raised in patent matters, saying you raised a claim knowing that the patent is invalid. And there has a lot of clarification and case law been going on. In trademarks, this is probably less of an issue, but be aware of that. There is sometimes, especially on e-commerce platforms, there are now new claims in the law, also by someone who received a warning or has been stricken down from a platform, which may lead to claims also by the other side. For that reason, because there's so much going on the platforms in China, and because actually the entire business moves online to a large extent, especially when you look at luxury goods and other goods, the Supreme Court, after the e-commerce law, also passed a further guideline on e-commerce, which is quite useful and should give you some guidance in how to approach this. We all know that working on the platforms is very cumbersome, very difficult, and that the requirements often are ridiculously high and the results are very often far from satisfactory. And that leads to the question, should I sue? Before doing so, one should take a look at these new rules, which show that there are some improvements, as this has been now clarified, what can be done, for example, blocking, disconnecting, taking down links, and that repeat infringers can even be pushed off the platforms. But the problem is that the specific measures of the platforms need to be followed, and that there's still a lot to be done. Many have heard of the famous backdoor access and deals done with platforms, and they do exist. So if you have a special arrangement with a large company, say starting with an A or others, it will help to get your complaints processed more quickly, but it will be a process not open to everyone. And that means running through the mill is often the only way to try to solve it with less costs and with a hope of being able to take down links. When they reappear, the battle starts. It's a cat and mouse, a whack-a-mole game to try to win this. Notifications are very important to get done right, so that you have the right cited, the right link cited, that you have everything in place what is required. Otherwise, you will be immediately rebuked. It's also important to realize that these e-commerce platforms are increasingly liable under the e-commerce law, but also under the tort law and other laws and regulations. And therefore, threatening them in some cases can help. It increases costs and time, but it does, in clear cases, help to get the ball moving. That means also that you have to make a decision as a right owner. Is it worthwhile to put more effort into it, or is it something I let go? All in all, there is a tendency trying to more look at how big a case is, how bad the case is for the courts, in order to support a claim. And that also means that given the widespread numbers of imitations and infringements, it's quite an arduous task, and you have to pick and choose the right targets to minimize the damages incurred. What about the liability of e-commerce platforms and who qualifies as e-commerce platforms? It was quite a narrow term. I will later on at the end of my talk will have a case example which held TikTok liable as an e-commerce platform, which is good news because a lot of advertising nowadays goes on platforms which are not strictly created for the distribution of goods. You see here, I put here the original wording of the court of what needs to be done. And basically, most of the platforms nowadays have policy in place, have a kind of a step system, and are ready to engage to some extent. But given the high number of complaints, you should not expect wonders. It's always a kind of a cat and mouse game, as I said before. Thinking about proving genuine goods also goes down to using good pictures or being able to really show, what type of specification and specific characteristics of your goods have been imitated. Also something to think about when you do product design. Now, if that all doesn't help, you nowadays, for the first time, can think about a pretrial interlocutory injunction. It is slow going. This is nothing which is widespread if you compare that to German courts, which quite readily in trademark infringement cases will grant you injunctions. This is something which is in the making. One should keep in the back of the mind that it just started in 2017 and has rolled on and has evolved now with the new guidelines just issued more or less a year ago with new guidelines issued, and it will take some time. The good news is interlocutory injunctions are now specifically enshrined also in the trademark law in Article 65. And they are also available not only for patent, trademark, and copyright matters. That was before the changes to the civil procedure law. That was the prevalent opinion among leading lawyers that there is no basis in the civil procedure law, so it's only available for those type of rights, not in cases of, say, unfair advertising, free riding, imitating, or saying I'm an agent of someone. This is something which is very common in China and which is also posing a huge headache to right owners, and that's now therefore also something you can attack under the new rules. The basis is the Article 100 of the Civil Procedure Law. And as you see, it talks about rule on preservation of its property or order the counterparty undertake certain acts or prohibit the counterparty to undertake certain acts. For the first time, there is something more than just evidence preservation or an enforcement of judgment before it has been rendered. That was still in the Civil Procedure Law, Article 106 and 7, but not so relevant in IP practice anymore. Now, this one is the new basis to rely on. It will require guarantees to put. It will require a very good evidence base to put forward, but there are now more and more cases where this is granted, even in cases of unfair competition. And that is a big change for the Chinese system and a big change for right owners if you have a big problem. I have put here also some explanations when there are urgent circumstances. One of them, very important, is a trade fair. So if you prepare for a trade fair, make sure that you have, the proper power of attorney in place, notarized and legalized for an attorney, able then to act on the trade fair and then to rely on these various new legal basis. Think about that. Such injunctions are still a tool which is not, a broad brush approach. The courts will be careful in not overdoing it. So you will have to be very specific in what you want to freeze, seized, or what behavior you want to be stopped. Here is also some more explanation on when an act preservation, that's the Chinese term, can be really claimed. You'll see here that in the end, you have to have a stable right. That is one of the issues which is important for patents more than for trademarks. And you have to show a kind of a balance of interests. The one is are damages enough to kind of remedy any infringement, or is there more? Is there, for example, damage to reputation? Or would any type of action have such a great impact on the other side that this is probably not proportionate anymore? And the public interest balance is also something which courts really take into account. So make a good argument when you move forward and make sure that you cover the basis of these guidelines to address all points in there, because that's what the court is going to tick the boxes on. When is a right stable? Just put here again, if you are in an invalidation procedure, if you're attacked and you try to use a trademark which is being attacked at the moment by non-use or by invalidation, there may be an issue. And you have to think about that disputes about ownership and others, like a licensee claiming that it's his trademark, etc., will also impact the likelihood of obtaining an interim injunction. What is, in the end, the main issue to keep in the back of your mind is that interim injunction or act preservation will be much harder to obtain nowadays compared to the evidence preservation. Evidence preservation is something which has now been introduced in Article 81, but is also introduced, as you see, in Article 100 to some extent, which also takes about preservation or securing property, and is something which is also available pre-trial. It is something which courts are nowadays increasingly to do, as there's a big discussion in China about the lack of discovery and the difficulties to put forward evidence. And this has been acknowledged by the Chinese Communist Party in the document I've cited at the beginning of that chapter of the presentation. And it is something which increasingly is replaced sometimes by burden shift of proof, sometimes by the court granting an evidence preservation order, in some instances, even the court himself taking on evidence collection, which a court now can do. It could do so under the old law, was never applied or very rarely applied. Nowadays, this is coming back into the game and is something to look at. You will need to explain that it's really impossible and cannot be expected to collect evidence, which in some trademark cases can be quite difficult if you could purchase, say, an infringing sample on Taobao or Tmall. To note in the end that all of that which has been inserted into the civil procedure law is also now in the trademark law. And what you see here is that the trademark law tries to strike a balance and says again that even if evidence preservation is granted, the court may still change it. And in practice, you need to be prepared to face that. One, increase of guarantee, that's often happening, that people start to ask for a higher guarantee, and courts can be very different in what type of guarantee they accept. There is a kind of a property guarantee of a mortgage provided by a special service company in China, which is accepted by some courts. Others still insist on cash, which needs to be renminbi, and that can be difficult to get into the country. So also these aspects need to be taken into account when you think about it, and that the court might change the evidence preservation order if the other side comes back with some reasoning statements or arguments and evidence. On the other hand, if the other side tampers with evidence which has been preserved, chances of the plaintiff greatly increase, because basically whatever you say will be taken at face value. And with those changes, one on the evidence preservation, two on the pre-trial interim injunction or injunction before a judgment has been rendered, and three, the damages and damage increases, which are now increasingly hailed and available, we enter into the case law and have a quick run through to some interesting cases. We start first with some cases which are related not to classical things like your trademark straightforward, but rather names, famous names of people. And one case which is quite popular and is often cited is the Michael Jordan case, where Jordan basically managed to show that the Chinese name Qiaodan in China would be understood and would always indicate himself, Michael Jordan, as the person, and that therefore use of that name Qiaodan would infringe his right. Michael Jordan had a slew of lawsuits and didn't win many of them. He lost also some very important ones. It's often cited as a positive example. In our view, it's probably not always the case. But it is important to show that if your reputation is strong, you should think about registering your Chinese trademark. And if you have a name in Chinese which is also well known or well received, and you can prove that by articles in newspapers, by accolades, by news shows, etc., then you should start to collect this and keep this in your evidence library to be able to claim also the Chinese language trademark for a name. Another example is BBC, which has just been also decided an interesting case because that was also a case where kind of an English language application service provider played with BBC, using a bit different, putting it here and there, and just alluding to it. And that still led to an infringement of BBC of the trademark, which was registered in China. So we see that it does work also if you infringers use it on WeChat or other mobile applications. But always an important element is, are you well known? Are you recognized? If you're an unrecognized name, things will be much harder to succeed. And that is also one case example which further demonstrates that. That's the Fendi case. What happens often in China is that you have someone who purchases original goods really through Daigou or someone else, and then offers them on the market in competition to a select distribution system. And lots of times it was tolerated by the courts. But in this case, one guy went too far and he used it on bulletin boards, shopping bags, etc. And the case went through many instances, and Fendi finally won because this type of extensive use also infringed the distribution system of Fendi and led to a kind of confusion. Is that now one of the select stores of Fendi, or is that a third party? It also indicates that having a trademark in class 35, the famous general class 35, which is very difficult to enforce, in this case, it paid off. So thinking about having there a trademark too will also prevent troubles against retailers who free ride on the reputation. Turning to damages and the general increase in damages, you'll see here one case which is also interesting in the health and wellness fitness area, where you see that WeChat was used as a promotional account, and it was quite clear that this was just an attempt to free ride on the brand, and that it tried to grow a business on the back of it. The interesting part was that WeChat showed a lot of sales, and there are kind of how many people have ordered that if you go on the WeChat accounts or on the Taobao accounts for that matter, and then right owners may rely on that to determine how much has been sold. And in that case, the infringer really rejected submitting account books and said, no, you don't get them. And in that decision, the good news was the court relied on this publicly available data and said, no, I mean, there's a period of time. There's 1,500 sales. We are sure you reached that and probably even more. And that's why we take the 1,500 and calculate the damages, and ended up with a higher damage than the defendant actually wanted. You need to be aware of that in China, due to the difficulties to prove damages, that damages are incurred because of the infringement. There is a new type of damage apart from your own losses, profits of the infringer, the license fee, or the statutory damage, which nowadays runs up to 5 million renminbi. There's a kind of a comprehensive damage, a damage which can go beyond the statutory damage, although it's not one of the three categories other than statutory damage. And there's a kind of an evolving practice based on whether there has been a wide extent of infringement. You're not able to show directly the damages, but it is quite clear that there has been some impact. And then courts may grant even higher amounts. So when you do sue, think about, when it comes to damages, not to straightforward claim statutory damages, but keep it a bit fuzzy and rely rather on this comprehensive damage approach if there is a large infringing activity which can be proven. The Xiaomi case is also interesting. because there you had also a big factory involved, and you had, quite a clear imitation behavior. Xiaomi is in China quite well known, and is in the end a very important competitor to come also for Western companies. And you see here that there was also a domain name registered, also something which is happening quite often, and that it was used on websites, online marketplaces, but also off-store. And then there was even an attempt to apply the name Xiaomi and add a descriptive term. In this case, it was life, Zhenghuo, and it was actually then also at some point even got by and passed by. Now, for the well-known trademark Xiaomi, it was recognized, and then it turned to the calculation of the damages. And the question was, well, isn't that also a malicious infringement and therefore should be a higher damage? And here, again, the online transactions of all online stores were taken into account. So when you claim damages, do look as broadly as you can and try to identify as many sales as you can, because it's not only the one specific store where you made the trap purchase, perhaps, but you can also rely on other stores, and you can try to claim then a malicious infringement to have a higher amount of damage calculations. Another thing to do is, when you do a trap purchase, make sure that you also look at the quality. If you can show lack of quality, that will also increase the chances of a higher damage award. All in all, the courts get more and more technical when they calculate, and they have boxes to tick. So it's important to try to deliver also information on each of the issues they will look at. When you look at these guidelines I mentioned earlier on the damages, I put them here for you later on to study. It will show you that for bad faith, there are a number now of types of behaviors which can be captured. And there are a number of new indications which the High Court put forward. Mind you that these guidelines are not binding on other courts in China, and they're strictly speaking only for the lower courts in Beijing relevant. But they're often adopted, they're often taken as reference, and they provide a good guidance also for you and your attorney to make this whole thing work. I mentioned before that e-commerce platforms are a big part of the infringement picture in China. And in this case, the interesting part was that TikTok was involved, and it's very hard sometimes to prove that also someone who's just giving you a platform to display videos, etc., that this is really an infringement. In this case, the court held that TikTok actually kind of assisted, was aiding and abetting, kind of supporting deal making and publishing information which were leading to the infringement, and thus held it not only as a kind of an entertainment platform, but also an e-commerce platform. But on the other hand, also attested that there had been some diligence being made, some procedures being put in place to mitigate and to prevent infringements, and therefore there was less success in the case on the damage side. But it's important to see that there are now increasingly tendencies to take on platforms which claim to be non-commercial or on another commercial focus, but actually do try to capitalize on their platform. Another case I think is noteworthy is the Burberry versus the Bainberry case. Also here, again, you take a brand, you make a similar name, you put up a lot of shops very, very quickly, and then you try to follow in the same malls and in the same sales places with that. That's a huge headache for many important luxury big brands, and really creates problems. In this case, it was even done more cleverly because he used a kind of a UK shell company, also something which is very popular among trademark pirates these days, to get the trademark and then license it to the infringer on the ground. But it did not help to no avail, because the Suzhou Intermediate Court held for infringement and said, no, this is not going to stop. Also showing a positive trend that if you have a well-known trademark, a good reputed trademark, and if you have stronger evidence on, you're able to show how the whole setup of the infringer works, that you may also in the end win a case, even though it's just a licensee or a franchisee. And the important part here is also that there was also the injunction tried and granted. And here you see, of course, one important factor was the well-known trademark. I'm not sure you would get that for any average trademark at these days. But you did have a very clear infringing pattern. You did have some urgency, and there was public interest and not concerned, and advantages and disadvantages of granting it were also not in disfavor of the applicant. The last case today is about a trademark, which is about the Chinese trademark. This was a brandy producer for wines, and there was an extensive use of also the Chinese equivalent to Penfolds, and that was Benfu. Benfu is something which has also obtained influence in China, and there was a competitor, Huaxia, who used similar names in English, Penfoils, Penfenils, and then eventually ended up in also trying to use the Benfu Niao and Benfu marks on wine and promotional materials. So inching closer every so a bit, trying to be mistaken and free riding on the reputation. And the good news here was, while the trademark was later on registered during the proceedings, the court even recognized that Benfu was an unregistered, well-known trademark in Chinese. Something also which shows the importance of protecting your Chinese name in the future. Should the political development further enhance mutual nationalism on all sides, it will be even more important to have a good Chinese brand. That was all. If you have further questions, we are happy to help you and be available to you. Some introduction on our new IP trademark agency and some introduction to Helen and myself is added to this presentation. We hope it was useful for you. We look forward to further working with you, or if you're a newcomer, to get to know you and your problems and challenges in China. And thank you very much for your attention. Have a good day and lots of success in China. Thank you and goodbye.
Thank you. Goodbye.